Lawyer Solictors, what is the strangest or oddest law that's won a case for you? Story 1, I won a case where the defendant in New York City tried to exploit a really stupid law, which I was able to use to win the case. This was a slip and fall case where my client had tripped on a piece of broken sidewalk outside of the Natural History Museum and shattered her arm and wrist. The law is that a property owner is responsible for the sidewalk directly outside of their property. The theory being, even if they can't fix it, they have a duty to warn people about hazards and mark the area off. The museum was owned by the city. There's another concept called sovereign immunity, which is that governments can't be sued without their consent. So the city had passed a very stupid law that they would be exempted from the rule that they can't be sued for sidewalk injuries unless you can show they were on notice of hazard. Meaning, you would have to show that you informed the Secretary of State, Governor, Mayor, etc. of the exact specific crack in the sidewalk before the injury occurs. And you had to do so in writing with ample time for the city to remedy it 180 days in advance IRC. Under normal circumstances, this is impossible because no one anticipates tripping on the sidewalk 180 days in advance with the foresight to write a letter to the mayor about that specific crack. Luckily, someone did have that foresight, and there was a nonprofit called Big Apple Maps which would go around the city and with maps of government property and record with insane specificity each and every crack in the sidewalk, pothole, protrusion, and other hazard, and then publish these maps while serving copies on the government, with the express purpose of combating sovereign immunity defenses in slip and fall cases against the government. I got a hold of one of these maps and visited the site, and I was able to take pictures of the section of the sidewalk where my client fell, and you could see newly placed concrete over the area in the exact position indicated on the map, showing where the sidewalk had been repaired after my client slipped. Basically, the government's attorney brought up the sovereign immunity defense and outlined all of the stupid steps I would have needed to go through to overcome their motion to dismiss. My response was, "Oh, you mean this?" and gave them the map. Immediate settlement. Story 2, my brother is a lawyer. He got a DUI charge dropped for a client guy, gets pulled over. Cop asks him to step out to perform the sobriety test after he admits to having consumed some amount of alcohol. He complies, but after stepping out of his car asks the officer if it's okay for him to reposition his vehicle, to move it further away from the road, because he feels uncomfortable being that close. The cop obliges. Apparently the charge got dropped because the officer willingly let an intoxicated individual operate a motor vehicle. Story 347 U.S.C. 227B restrictions on use of automated telephone equipment. Law student working at law firm. We have a fax machine that gets tons of spam faxes. Our chief partner has a vendetta against spam, and he uses it to give us practice in researching and writing petitions. So we catalog each fax, send replies to take us off the list, document everything, and wait for them to fax us again. Then we follow up with an FCC complaint and demand letter. A couple times this has ended up with the person getting mad and sending us retaliatory faxes, black sheets of paper. If they stop sending, we don't do anything. But we've gone to small claims a couple times and gotten 500 per page a couple times. We also got someone trying to sell drug through fax, but we just turned that over to the police. Story 4, the Canadian Interest Act specifies that all interest must be specified in a per annum percentage. If it is not, it's struck down to 5 simple interest per year. The number of lenders and creditors who try to pull off a 4 monthly compound interest but aren't familiar with that provision of federal law. Story 5, I had a case where a guy was charged for running a red light. The thing is, he had been sitting at the lights for 5 minutes, and it hadn't changed. The wording of the specific section under which he was charged related to stop signs at traffic lights and referred to them as traffic regulation devices. I successfully argued that as the traffic light wasn't regulating traffic, and he got off, I couldn't believe it when the judge ruled in my favor. Neither could the police prosecutor. Story 6, the weirdest case I have ever dealt with was Jolie v. Palladier. 1999 J. No. 1728 SCJ. I did some research for this case when I was a law student. Some background: this was at a time when the Ontario Court of Appeal had held that if there were any factual matters in dispute, a case could not be dismissed on summary judgment. That is not the case today. It was discovered that this position basically ruined summary judgment as a useful process. But it was at the time. In such a motion, all facts alleged by a plaintiff would be assumed to be true. What happened was this: a man sued, among others, the College of Dental Surgeons for persecuting him and interfering in his ability to live as a generic Martian. The plaintiff claimed he had been cloned from space debris NASA found in the 1960s. He claimed he had a genetic test to prove this, but it had been falsified by the CIA as part of the conspiracy against him. Well, Naturally, this claim raises the concern that the plaintiff was bonkers, but there was no evidence aside from his bizarre claims of that. In court, the case was decided on two alternate grounds. First, on the boring grounds that the case was patently frivolous and vexatious because it was absurd. However, it was also decided on the more entertaining basis of standing. Justice Epstein held that only a person could commence an action in Ontario. The rules of civil procedure define a person to be either a human being or a corporation. The plaintiff's old case was based on him being a Martian. If he was not a Martian, his case had no merit. If he was a Martian, he lacked standing to commence a lawsuit in Ontario. In short, we now have precedent that Martians cannot sue in Ontario. Story 7, I have one where we won, but didn't quite go as planned. I had a client a while ago who was incarcerated at a state prison farm. Inmates had to spend 40 to 60 hours a week preparing slop for the hogs from expired restaurant food and cleaning the hog barns. He reeked every time I met with him. Even after showering, he said it was miserable. Well, he found out that some Muslim inmates who couldn't work with pigs were offered to be able to work at the police horse stable instead, 5 minutes down the road. He wanted to sue, saying that stable work is much less revolting than hog work, and that this amounted to unequal punishment on the basis of religion. I thought he had a point. Well, the case didn't get thrown out and actually got some traction, but then the prison changed their policies in response. Inmates who couldn't work around pigs or didn't want to would instead be transported to a factory chicken barn in the next county over for work each day. He asked that I drop the lawsuit, and the Muslim inmates were not happy with him. Story 8, over 10 years ago, I had been at fault for rear-ending someone else. I had no insurance and my license had expired. I don't think I need to mention that I was in a very destitute, low place in life, struggling with almost every conceivable aspect of living. The cop was very kind as we talked, but wrote me a ticket for it all. One was kind of fix-it ticket about my suspended license. I sorted that out in the days after and nothing came of that ticket. The cop had mentioned that he had to write the insurance ticket, but to take it into court and get it lowered, I was desperate to try and get my $800 insurance ticket lower because I couldn't afford something like that. So I took the cop's advice. I went into traffic court weeks later, and when it was my time to chat with the judge in front of everyone there, the judge looked at the ticket, stopped me, and said, "I would like to use Mr. South Seattle's case as an example to the gallery. I almost died." He went on, "This is a court of law, but it is also a court of fairness. It seems as if the officer didn't write the date of the incident in the ticket. I can't hold Mr. South Seattle accountable to this." My jaw dropped. I stood there. The judge told me I was free to go twice before it registered. I'm pretty sure that cop deliberately didn't write the date on that ticket. Thanks, officer. Story 9. There was a case here in Hawaii that got thrown out like this. Someone got pulled over because the police saw she had way too many passengers in the car. Then they noticed she was drunk. Open and shut case. Well, apparently in Hawaii, there's no law defining the maximum number of passengers in a private vehicle. So the issue was that all the extra passengers weren't wearing seatbelts. Well, this failed also because the law only says that every available seatbelt needs to be in use. If you have 6 passengers and only 5 seatbelts, there's nothing at all illegal about the 6th being unrestrained. So, since there was no probable cause to pull her over in the first place, even though she was indefensibly drunk, the whole thing got thrown out. Hawaii has some very counterintuitive laws. If your truck has seats installed in the bed, your passengers must be buckled up. If not, they could just party back there while anyone in the cab unbuckled would get you a major ticket. People regularly ride down the freeway in truck beds while sitting in lawn chairs. Story 10, I got a pro bono client's removal by USAS canceled. He had a low-level drug possession conviction from the early 1980s. During that brief period, the active ingredient of Imodium was illegal under state law, but not federal law. So I successfully argued that they couldn't prove it wasn't a conviction for possession of substance that was federally legal at the time, and as such was not subject to removal. The argument worked, and my guy went back to his business and his family. Story 11, typical IANL. But the first and only time I ever used the subway station's emergency door to get to the train, the ticket gate wasn't working. It was 3 a.m. I was a drunk college kid trying to catch the last train home. I got caught by 2 subway officers and given a ticket with a huge attempted fare avoidance fine. I showed up to the hearing in desperation, and they ended up having to drop the fine as they were reviewing the case with me, because one cop had recorded that I entered through the right-hand emergency door, and the other wrote that I entered through the left-hand emergency door. Never been so grateful in my life. Story 12 had a guy in USAF basic training that should have been a lawyer. When pulling dorm guard duty, we were supposed to ask anyone requesting entry to show their military ID through the window in the door and compare the name shown to an approved entry list. Failure to confirm ID before allowing entry was a security infraction. So this one dude is dorm guard when a TI training instructor is going around from dorm to dorm to make sure the airmen on duty are following procedures. The TI knocks on the door and demands entry. For whatever reason, the airman lets the TI in without asking to see ID. The TI blows a gasket and starts screaming at the airman how much trouble he's going to be in when the TI reports what happened. He demands the airman hand over a Form 341, which is used to document rules and infractions. Airman, sir, we'll give you a 341, but I think you should know this door is broken. TI, WFT are you talking about, airman? Airman, sir, we found out if you kick the door on the bottom left corner, it opens whether it's locked or not. TI, show me what you're talking about. The two step out into the hallway, and the airman shows the TI where to kick the door. Airman, sir, let me step back inside and lock the door, so you can try it yourself. The airman steps back inside the door, then locks it. The TI tries kicking the door, but it remains locked. TI, airman, I thought you said this door is broken. Airman, it worked the last time I tried it. TI, well, it looks like it's working fine now. Open up and give me a 341. Airman, sir, if you are requesting entry to the dorm, it'll have to see your ID first. Story 13. In 2016, prison inmate John Modi was charged with escaping from the prison in which he was incarcerated, which is a crime in Ohio. The prosecution, however, failed to establish that the Hocking Correctional Facility, and therefore the crime, was located within the court's jurisdiction of Hocking County, as all witnesses potentially able to offer testimony on the prison's location had gone home for the day, and, incredibly, no one remaining could provide references allowing the court to take judicial notice of the prison's location. The charges against Modi were dismissed, and he was allowed to return to prison to serve his sentence, but at least without additional charges concerning his alleged escape. Story 14. A guy got drunk and decided to ride his horse through town. This was a small town in North Carolina. Well, he would stop at each intersection and fire his pistol in the air like some Wild West cowboy. Anyway, the guy was charged with a DUI and discharging a firearm within city limits, which was a felony. So as one would soon find, is not just mandatory, but a law that you must fire your firearm into the air at an intersection when coming through town on your horse. An old blue law that never got erased. He still got the DUI, and his horse got impounded, but the dumbfounded judge dropped the other charges. Story 15 had a case where my defendant opponent filed an appeal from an administrative agency to the local circuit court. The requirements for filing the appeal are very strict, and the filing must include an appeal bond executed by the individual defendant or a corporate officer. When my opponent's assistant electronically filed the appeal, she attached a PDF of the bond without the corporate signature. There's no question in my mind they had the bond with the requisite signature and simply attached the wrong version of the document to the filing. Wish I could say there was a huge court fight over this and I got to slam my opponent, but that's not how this works among professionals. I waited until after the time to correct this error had passed. I then politely called my opponent, told him that I was holding the I win button, and that I'd be filing a motion to that effect in a week. My opponent came to me with very favorable settlement terms within days. To this day, I don't know for sure if my opponent ever disclosed his mistake to his client, but I doubt it. Story 16 had a client who was a truck driver. He got various penal infractions for issues with his truck, several $1,000s in fines basically. Anyway, the evidence is pretty damning. Lots of pictures showing defects, detailed description by the traffic control officer, and so on. However, to find him guilty, the prosecutor technically has to prove that the vehicle he was driving is considered a heavy vehicle. The law says 3 heavy vehicle means a road vehicle or combination of road vehicles, within the meaning of the Highway Safety Code, having a gross vehicle weight rating or gross combination weight rating of 4,500 kilograms or more be a bus, minibus, or tow truck. Within the meaning of that code, see a road vehicle subject to a regulation made under Section 622 of that code. The traffic control officer had not listed the weight of the vehicle in his report. There's pictures of it, clearly an 18-wheel truck, in the report, but no weight written anywhere, so I told the judge that the prosecution hadn't proven the weight of the vehicle per the definition of heavy vehicle. The pictures don't prove the numerical weight, just the shape of the vehicle. She had no choice but to acquit him because all of the infractions he had received were for a heavy vehicle operator. So he can't be guilty if they can't prove he was operating a heavy vehicle. Story 17. I once had a client who woke up in the middle of the night to the sound of someone in his home. He retrieved a Colt 1911 from a bedside drawer, walked into his living room, and confronted a figure in the dark. The person didn't identify himself, but moved toward my client, who fired a single shot that went through the person's shoulder. Turned out it was my client's stepson who had snuck out, been drinking underage, and stumbled home. The problem with the situation was that my client was a convicted felon several times over. That meant that while the shooting itself was legally defensible, his possession of the firearm was not. We looked into the history of the gun itself. As our client had indicated, it had belonged to his grandfather, who had served in the U.S. Army in the early 20th century. Ultimately, we were able to bring multiple experts in and establish that the gun had been among the very first batch of firearms distributed from Colt to the U.S. Army at the Augusta Armory. Florida Statute 790.001 creates an exemption of firearm-related laws, including the prohibition for felons to possess a firearm if the firearm in question was an antique, meaning it was manufactured prior to 1918. Since we could establish the history of the firearm to have been manufactured before 1918, our client couldn't be prosecuted for the offense and got out from underneath a potential mandatory prison sentence. Story 18 had a friend who's a lawyer. Apparently, his city had made a new law that if you don't pick up your dogs, you can be made to do so with bare hands after hearing how effective that law was in some country in Europe, but the law got thrown out for being a cruel or unusual punishment or something like that. So he recommended an alternative means of getting it into the law, make it be the defense to the crime instead of the punishment, and increase the punishment to incentivize people to do it. The draft of it he sent me was something like, a person who fails to immediately remove the waste of their pet or any animal under their control from public lands violates the animal waste ordinance and shall be sentenced to a minimum of 3 days in jail and no more than 30, in addition to a fine of up to 200. It is an affirmative defense to this offense if, upon being confronted by an officer, the offender immediately admits responsibility for the offense, and be at the direction of the officer, picks up the pet waste using only the offender's bare hands until it is disposed in a legal receptacle. No penalty shall be imposed. If the offense is caught after the fact, and the offender's pet's waste has already dried, washed away, or been disposed of, or if the offender expresses willingness to employ the affirmative defense above, but has visible cuts, scratches, or other abrasions on the hand, or any illness, or is pregnant, the officer may, at his or her discretion, ask the offender to pick up a different animal's waste with bare hands at a later time as appropriate. This shall satisfy the affirmative defense above. The waste may come from a police dog or a police horse. Story 19 but I won my case by exploiting a legal technicality in my jurisdiction. My case needed to be tried at a certain court, but they tried me in another court, and by trying me in the wrong court, basically broke the law. I made them aware of this and had my case dismissed. Story 20 not a lawyer, but I got a charge dropped because of the cop's bad handwriting. I got a ticket on a Monday night for speeding and was given a court date of like 2 months from then. About a week and a half later, I get a letter in the mail that I'm being charged with a failure to appear for court. I'm in court 2 days later for that. Until the judge not guilty on the FTA and no contest on the speeding, after asking him to just look at the date on the ticket and my supposed original court date, he sets them down and goes, "You have a point there. Not guilty on the failure to appear." "And how do you plead for the speeding charge?" I replied, "No contest. I was speeding, Your Honor." He looks at the ticket, sees that the cop had initially put 10 over and in the notes put my actual speed like 20 to 30 over, and goes, "Yes, it certainly looks that way, lol." Story 21. I had one where a client was contesting a will. Halfway through the case, the other side argued that my client was set to inherit less without the will if we won than she would with it if we lost, and argued she lacked standing to attack the will. The decedent had a very old will that benefited our client's deceased mother, but that will had been revoked. We found a very old doctrine in a footnote to something else entirely, and argued to the judge that the law assumes you'd rather die with an old, revoked will than with none at all. Therefore, we argued he should look back to the prior will. Since our client would inherit her mother's bequest under the prior will, he held our client had standing to bring the will contest. We ended up settling the case shortly thereafter. Story 22 and this story isn't that great, but it's mine. I look back on it and think that telling the truth seems like an odd way to win a case. Cop said he got me doing over 85 and a 65 based on a visual approximation on about a 1 to 2 incline. Put 73 on the ticket to give me a break. My old car couldn't go past 83. Took it to the track once just to find out and had a little slip to prove that, though that was hardly evidence. Prosecuting attorney asked me who I was. Then, well, what's your defense? I told her it seemed like a bad idea to talk to her about anything and that I wouldn't be doing that. She added enough nonsense I would have lost my license. Opened by discussing that fact with the addition of the charges. Noted prosecution's behavior was malicious and vindictive. Got told I couldn't say stuff like that, but she affirmed the exchange happened. She added a bunch of charges like driving without a seatbelt, reckless endangerment operation, a higher speed charge. Eluding the police, he lit me up on a bridge. I put my flashers on, then pulled over slightly after the bridge because it wasn't safe. Started by asking the officer to describe the day. Sunny, dry, minimal traffic, straight, smooth, flat, well-kept road. Given the road conditions, the officer agreed that my vehicle was well under control and did not merit the conditions for reckless. He stated that with his vehicle and training, he would have no issue safely exceeding 100 miles per hour under those circumstances. Kept talking to the cop. He said I had my seatbelt on. Said I was polite. I asked him if he felt that my delaying the stop was for his safety or to hide or destroy evidence. He noted my car was spotless, and I explained my reasoning for pulling over late, offering to let him search it if he was so inclined. He declined. A 95 Jeep Cherokee, so no trunk and big windows. Offered to let him search my backpack. He declined. He said I was doing 85, gave me a break for the speed. I asked him again if I was doing the speed on the ticket. He said no. He asked me if I knew how fast I was going. I said, not exactly, but I didn't think I was speeding because I always double-check my speed in that area where they sit, and my vehicle probably couldn't do 80 going up any kind of incline. The officer clearly disliked this prosecutor, as I brought up that made her look stupid. He kept this huge grin. I asked for everything to be dropped because based on the citation and testimony, the ticket was incorrect, and the rest was just spite trying to punish me for wanting to experience the judicial process. I asked the judge if this sort of behavior from prosecutor was the type that should be reported. He was non-committal, but urged me to report it if I believed as much. I reported her. Nothing came of it that I knew of. He dismissed the ticket. Talked to the cop on the way out. He said something like, okay, but you know you were speeding. We laughed. I told him no idea, but innocent until proven guilty or something. Really pleasant and solid guy all over. He let me pet his dog. I probably was speeding, but I couldn't be doing the speed he stated and definitely wasn't doing the one he wrote. So, meh. Next car had cruise control. Story 23 once won a case that forbade the possession or transport of human urine in order to adulterate a urine screen. It wasn't human urine. It was fake lab-made urine from a website. Edit realizing I kind of messed up the phrasing here. I had a client who was caught with a little container of alleged urine that he may or may not have been about to use to mess up a drug screen. Since he hadn't messed with a drug screen or actually tried to mess with one yet, he couldn't be charged with that. So he was charged with trying to transport human urine with the intent to adulterate a urine screen. Meaning I got to argue that 1, the prosecution hadn't proven it was human urine, they hadn't tested it. 2, they deprived us of the opportunity to test it because the officer poured it out before giving the container back to the client. 3, my client could literally testify it wasn't human urine. He's still known around the office as Human Urine Guy. We have a lot of nicknames like that around here. Human Urine Guy, Drywall Guy, Donkey Kick Guy, Fire Truck Guy, Backpack Girl, Cornhole Board Guy. Bonus, the prosecutor got offended because I made a motion to suppress the search of my client based on violation of the Fourth Amendment. Prosecutor thought Wet agreed that the search was good. The search was good based on the facts in the police report. Not my fault that the police officer testified like an idiot once he got on the stand. Story 24, I once got out a parking ticket by refusing to admit I was the driver. In the UK, parking companies that use automatic number plate recognition can get the contact details of the registered keeper of a car from the DVLA or DMV and send them the fine in the post. But I did some Googling and found out that legally, it's not the registered keeper who is liable for the fine. It's whoever was driving at the time. This isn't always the case. There are situations where they can hold the keeper liable, but in my specific case, this didn't apply. They really don't like you knowing this. Their letters are worded very carefully to give you the impression that you're liable for the fine as keeper of the vehicle without ever actually outright saying that. And they do the where you can either pay a reduced fine now or appeal and pay a bigger fine later. I appealed. I didn't lie and claim I wasn't the driver. Instead, I just pointed out that they're contacting me as the registered keeper, that the registered keeper isn't legally liable to pay the fine, and that I am under no obligation to give them any details of who was driving at the time. It took months and 2 appeals, but eventually I won and didn't have to pay the 20 fine. I would have paid, but I felt like I hadn't done anything wrong. ID not parked illegally or overtime or not paid or anything. ID just forgotten to validate my parking after shopping at Tesco. Story 25 I annul, but I got my case for reckless operation of a vehicle thrown out, drop it, forgotten a budik, what to call it. I was younger and was one of those kids with a loud muffler driving all over the place. Eventually, it caught up with me, and I got 3 major speeding tickets, 30 miles per hour over the limit within 30 days, which is an automatic summons for reckless operation. I arrived at court and waited as they called people up and handed out punishments. After hours, everyone had left, and the state officer walked up to me and asked why I was here. I presented my summons slip, and he had no record of it. We went to the office, and it wasn't even in the computer. They gave me a new one and told me to come back in 90 days. Lo and behold, in 90 days, for some reason, it still wasn't in the computer. It was as if I was never pulled over at all that final third time. The officer must have slipped up and forgot to submit some kind of paperwork. They tried to give me another one, but I put up a stink saying that I had held up my legal obligation, not once, but twice, and I was going to get a lawyer involved. They slapped me with a $100 fine and sent me on my way without any further repercussions. Biggest bullet I've ever dodged thus far. I likely would have lost my license for some amount of time. Chances are with a lawyer, I wouldn't even be fined, but that was too much hassle. Besides, I had broken the law, and I deserved a fine at the very least. Story 26. Many years ago, I actually saw this in the newspaper, but am now thinking it's an urban legend because I can't find anything online about it. Apparently, a 20-year-old man was cited for underage drinking in Michigan. He argued that since it says in the Michigan state constitution that life begins at conception, and that since he was over 20 years and 9 months old, he was obviously old enough to drink. And he won. True or not, I can't say. At 20 years and 3 months old, maths are hard. Story 27. Not a lawyer, but I did enough law research to get myself out of a parking ticket one time. When I was in college, I was in the marching band. We had a storage room in the basement of one of the dorms. I was going to get something out of the storage room and parked in the loading dock behind the dorm. There was just enough room next to a dumpster to fit my car. I didn't want to spend $5 on a loading zone pass for parking services because I was a broke college student, so I just parked. I was only going to be 2 minutes anyway. I finished picking up what I need to. Sure enough, I come back out of my car to a parking ticket. Except it isn't the 25 ticket for parking in a loading zone. It's a 75 ticket for parking in a fire lane. WTF, there is a single sign at the very front of the side road leading up to the loading zone, but no curb paint, no indication of where the fire lane started and where it stopped. I called parking enforcement telling them this, and they wouldn't budge. Fine, I took pictures of the loading dock, and I submitted an information request to obtain the evidence pictures. I got the pictures and started researching fire lane requirements in the state. What I found clearly indicated that curb stripes were mandatory. I called parking enforcement and told them what I found, and they still wouldn't budge. Frustratingly, I looked at the law again. The part they cited me for said that nothing could obstruct a fire lane at any time. I looked back at the evidence photos and saw the dumpster next to my car. If this was a fire lane, then the dumpster was blocking the fire lane to the same state law. They cited me with said that non-vehicle obstruction of a fire lane was subject to a fine of $1,500 a day. I found satellite imagery from 4 years prior showing that the dumpster had been there for at least 4 years. So I argued to university parking enforcement that if this was a fire lane, then the university had been obstructing it for at least 4 years and would owe the state $2 million in fines if I reported it. The parking ticket disappeared immediately when I sent the appeals committee their own evidence photos, sat imagery, and the same state law they cited me with. I drove by a week later and the dumpster was gone, the curb painted, and 2 brand new fire lane signs were up. TLDR, got parking ticket for parking in a fire lane at my university. Successfully argued the university owed $2 million in fines to the state if it was really a fire lane. 75 parking ticket dropped. Story 28. Whoa. I annul, but when I was in high school, my friends and I used to flower bomb cars. This is stupid, and you should not do this. Pour a half cup of flour onto a damn paper towel, twist into a little sack, and tie it off with a rubber band. Throw it at someone something. I was caught by police and given a fine of $360, the maximum allowed with what I was being charged with. I contested it because I was broke and figured the officer wouldn't show up to traffic court. The language of this law was oddly specific. I was charged with throwing or placing a dangerous or injurious object in a roadway. If the language had been left at this, it would have been pretty easy for them to enforce this, and I would have had no choice but to pay. I also want to be clear that I definitely did something stupid and could have hurt someone. I deserved whatever was coming. But the law went on to define, with strange specificity, what constituted a dangerous or injurious object. Included things like rocks, pine cones, plates, tires, and on and on and on, but nowhere did it say anything about flour or food or paper towels or rubber bands. The room was divided into normal traffic violations like speeding and whatnot, and then myself, and one other person were the others, and we got to go first. I had no idea what I was doing, but when it was my turn, I got up in front of the court and pulled out a law book and read this, and then presented a flower bomb I made and made a nervous attempt to explain why I didn't think this met their definition. The DA and the police officer who gave me the ticket had an exchange, and then spoke with the judge for a minute. They did not look all that concerned or pleased, but after a minute or so, the judge just said I was free to go and that the fine was dismissed. A few people started laughing and a bunch of people clapped, which I must admit felt kind of awesome. Again, this was a dumb thing to do and not exactly in the spirit of the law. I was a turd who got away with it. but I have a story from Australia. I received a letter from SDRO State Debt Recovery Organization stating that I had unpaid debts. They gave me 30 days to pay them. Otherwise, they would be arriving at my home to repossess everything I owned. This included furniture. Furniture was specifically mentioned in the notice. This really pissed me off. I've never had unpaid debts. In addition, I lived in an app with my brothers who were these clowns to threaten they would take all my furniture and belongings. With 30 days notice, when I checked the details of the notice, it was for unpaid traffic fines from more than a decade ago. The most recent notice was from 13 years ago. The oldest was from 15 years ago. With interest and other penalties, they wanted a couple of $1,000s. Big money to me at the time, 20 years ago. Now, when I was in my early 20s, I did have a motorbike, and I did rack up a few speeding fines, but I paid them. Back then, you had to pay them, because if you didn't, your license got canceled. My license had never been canceled. I paid the fines by money order. After about 5 years, I got a new wallet, looked at the stubs for the money orders, laughed at myself for being paranoid, and threw them out with my old wallet. Surely Noon would want them by now. And a few years later, these notices arrived. I called SDRO to say these charges were invalid. They had been paid years ago. They said, no problem, we just need a letter from the issuing authority to say so. I checked, the issuing authority no longer existed. It had been closed down years ago, and a new government authority, the RTA, now existed. I called the SDRO back, and they said sorry, but unless the relevant authority says the debt has been paid, we cannot cancel, but the relevant authority no longer existed. This seemed Kafkaesque to me. I then called the Sydney Central Court. One of the clerks there took pity on me and gave me a huge tip when they shut down the old government authority and started up the new one. They had, of course, to transfer a record from the old one to the new one. She thought my payments might have been made at the time of the transfer and somehow not been recorded on the old system or the new one. My first clue, I contacted the SDRO again and told them I believe these debts have been paid and been accidentally resurrected in the course of switching systems. This time, one of their lawyers wrote to me and said I had not proved this was the case true and that the debt still stood. And here's where I had my moment of genius. I told him the debts were paid, and because 7 years had expired, I no longer had to provide proof that I had done it. In the next letter, he told me that because the debts were for traffic offenses, they became a criminal matter and did not expire after 7 years and still stood. My next letter, I told him it only became a criminal matter if they were unpaid. However, I said they had been paid. Therefore, they were no longer a criminal matter. Therefore, I no longer had to supply proof they had been paid. His next letter, you have to prove they have been paid. Until then, it remains a criminal matter. My next letter, as you are claiming a debt against me, I don't have to prove they are unpaid. Instead, it's up to you to prove they were. In fact, because the debts you are asserting are so old, there's been a denial of natural justice. The law says I don't have to retain receipts for more than 7 years. But by trying to collect on a debt so old, you're trying to force me to supply proof that according to the law, I no longer need to have. From there, I escalated things to the ombudsman. And I won, or the ombudsman did. The debts were canceled or assumed to be paid off. I'm glad I won in the end, but can you imagine receiving claims for debts more than a decade old? How ridiculous and unfair. Now, 30 years later, we have robo-debt in Australia. And I suspect it is illegal to try to force people to prove things about their income from more than 7 years ago.